Jude Mattingly, Office of Planning Staff, 444 South 5th Street. Okay, so before you is a waiver of Louisville Metro Code of Ordinances to allow the registration of 2 short-term rentals within 12 months of a citation. Next slide, please. So a conditional use permit was approved under 17 CUP 1062 that allows both units of a duplex to be used as non-owner occupied short-term rentals. A previous property owner was issued a citation on October 30th of 2024. That previous property owner came before the board to request the waiver on December 2nd of 2024 that would have allowed them to register both units as short-term rental, and the board denied those waivers. Next slide, please. So Jefferson County PVA records indicate that the property sold to a new owner known as Grace Investment LLC in March of 2025. The new owner has attested to having no prior affiliation with the former owner of whom received the citation. Next slide, please. So when we've talked about these waivers, we've talked about exceptional circumstances in which staff might be more inclined to suggest that the board approve a waiver to allow a short-term rental to register. A change in ownership is one of those situations. A change in ownership in which the new owners do not have an affiliation with the offending party. In theory, the new owners had nothing to do with the violation that got the previous owner a citation. So if the board, and obviously it's going to be largely based on testimony that you're going to hear from the applicant, but if the board were to grant the waiver of LMCO, the property owner would obviously have to register both units as short-term rentals with the Office of Planning, and the property owner would still be subject to any and all Metro Code of Ordinance standards, the standard of review that's contained in the conditional use permit on site, and any and all conditions of approval that may be held within. So next slide. So your required actions would be to approve or deny a waiver of Louisville Metro Code of Ordinances, section 115, 516 D1, to allow a property owner to register 2 short-term rental units approved via 17 CUP 1062 within 12 months of being issued a citation. And I can imagine there might be some questions on this one.
I don't have any questions, actually. Not at this point. Not at this point. Members? Thank you.
I did have a question. Sorry.
Yes.
So in this material, again, the change in ownership occurred last month.
Yes, sir.
And so there is obviously on the behalf, I shouldn't say obviously, but apparently on the behalf of the property owner and the applicant, some expectation for moving through this process rather quickly with a certain sense of urgency, which is a sense of urgency that is not shared by me. I mean, we need to take our time and do this according to the proper standards of review with all the appropriate information. I see that there is already some feedback available from neighbors that give us some additional context for reviewing this. But can you give us any insight on what is the sense of urgency that brought this to this BOZA meeting?
I mean, I think the applicant might be better suited to speak to that, but my assumption would be that a new property owner bought a property that with the intended use of using it as a short-term rental and would like to advocate that a penalty that was incurred by a previous owner should not necessarily continue to punish them.
Gotcha. Thanks.
And just to clarify one thing, because this one is an unusual situation.
Seems like it.
Yeah.
The conditional use permit was granted before the requirement that you had to renew within 6 months, which then we changed to 30 days. This has been an evolving ordinance. So they have a conditional use permit that's in good standing that doesn't require them to keep that registration like one that was issued after 2019 when we put that into place. So this is an odd situation where the owner has a valid conditional use permit allowing short-term rentals, but can't do them because they can't get the registrations because the previous owner didn't do good paperwork and basically didn't file the registration in a timely manner, and then got cited by enforcement for operating without the registration. So I've been working with short-term rentals since their inception, and I've never seen a situation quite like this, so it is unusual. You can ask the owner on what circumstances they bought the property and why they're ready to move now, because they could do things like long-term rentals immediately if they wanted to. But I just want to note that the conditional use, normally when we do these, the conditional use might be in an area where it might be heading towards a revocation, not in this case, just because it was approved under a different set of rules, the original set of rules basically for short-term rentals, and they're kind of have non-conforming rights to those.
Okay, thank you. All right. Thanks, Jude.
Thank you.
I have a speaker card for Mr. Tandy. How are you today?
I'm fine. How are you?
Doing well, thank you.
Good.
Name and address, please.
All right. David Tandy with Denton's law firm, 3500 National City Tower, 101 South 5th Street, Louisville, Kentucky, 40202.
All right. Mr. Tandy, do you swear the testimony you're about to give today is the truth?
I do.
Please proceed.
All right. Thank you. Good afternoon to all of you. David Tandy here on behalf of Grace Investments, LLC. I will state that for I was having some flashbacks from your previous deliberations to some of the council meetings, and I commend you for the way that you handled that. But as it relates to this particular matter, Mr. Tawari and his wife are the owners of Grace Investments, LLC. They purchased this particular property at 2021 Bonnycastle Avenue in March of 2025, as has been stated previously. They purchased it from the previous owner of the property. The property in of itself right now is being rented on a long-term basis, more like on a month-to-month basis at its presently. However, the new ownership that has purchased the property desires to rent it in a short-term rental consistent with the way that it had been rented in the past. You will note that the violation for which the 12-month probationary period was instituted was because of the lack of proper paperwork being filed by the previous owner and their management company. In this case, for Mr. Tawari, he was not a member of the previous ownership group that owned the property, nor has the management company that was previously involved with the management of the property, nor have they been retained to manage this property. He has selected new management in the form of Synergy Services to be able to provide those services. Outside of that, all other consistent operations of a short-term rental for this particular property are intended to be utilized. And in the history of the property in and of itself, it's found that there's been harmonious occupancy and usage of this property as a short-term rental in the past. And so the desire here is, in light of the fact that we are dealing with a piece of a property that has essentially a grandfathered conditional use permit attached to it. That is why we're in this unique situation that we're in. But are looking to move forward in allowing for the Tawaris, the owners of Grace Investments LLC, to then be able to subsequently go ahead and operate this as a short-term rental.
Okay, members, any questions for Mr. Tandy? Yes.
Mr. Tandy.
Mm-hmm.
So just to reiterate, even though this property is currently being used for more extended term rental, the property owners, the applicant's aspiration is to have the ability to turn it into short-term rental, non-owner occupied. And that for our consideration, for Bose's consideration, the difference between the previous owner and this current owner includes not only change in ownership, but also change, if I understood it correctly, the management of the property. And that I think if I understood your testimony, that the entity that will be managing this property has a superior reputation or history of managing these properties in a way that is compatible with the quirks of the neighborhood, the expectations of the adjoining property owners. Did I get that testimony correct?
Correct. I mean, essentially, if you wanted to make a long story short, we've essentially wiped the slate clean from the previous ownership that then failed to register in a proper manner. And then I think in terms of my review of the record from the previous ownership, the issue was they were first cited on October the 23rd of 2004 for operating without registering, and then a week later they were still found operating that same property without registering again. So essentially, when you get which led to the October 30th citation, and then subsequently led to the 12-month probationary period being attached. Again, it's like when they have a previous actor, they got their hand caught in the cookie jar twice with them. In this case here, we've completely wiped the slate clean with new ownership and with new management. And I think there, of course, if you go back and look at that record, there were some other circumstances that were surrounding that particular management that we're not dealing with here.
And then back to my original question of staff, this sense of urgency to be able to start utilizing that for purposes of short-term rental versus it's currently occupied and being rented anyway. What is the sense of urgency?
Well, exactly? So the previous rental was done by the previous ownership for essentially a monthly basis. That rental has expired because it expired on April the 1st. So now the property is sitting vacant. The desire of the Grace Investment Group is to try to maximize the revenue that can be generated from that particular property, as any of us would. Should we have some type of investment property, we want to use it at its highest and its best use. In this case, short-term rental would be able to allow us to be able to do that. As it relates to the will of this board, in order to, and we understand why you want to, have rules, you expect people to follow them, and then you have punishments that need to be administered. In this case, you set forth a 12-month probationary period for the previous owner. 6 months of that have been served. So your desire to make it very clear, we expect property owners to follow the rules and to register their property as short-term rentals have been heard loud and clear, particularly by that previous owner. However, we're a different group. We understand coming into this what is being required of us, and as such are moving forward in such a manner that would allow for this short-term rental to be operated in a manner that's consistent with the Louisville Metro Code of Ordinances, while at the same time being respectful of the neighbors in the surrounding area.
And finally, one question. So wipe the slate clean, new owners, new management, and yet within the information we've received, still some residual resistance within the neighborhood for this continuing as a short-term rental because of alleged uses that caused irritation, commercial vehicles parked out front, who knows what else, long legacy. Again, this is all secondhand. It's true that this is written correspondence, but without us being able to examine the person that's submitting this information, we just have to accept it at face value. But just for clarity, to the Grace Investments LLC, which you're representing, that there is expectations from the neighbors for whoever operates it to do so in a manner that is neighborly and reflects the respect of and expectations of the neighborhood, that there's clarity in that regard.
Well, yes, to the extent that you're expressing that as a way of kind of putting that on the record and making sure that the current ownership understands the desire of the neighborhood to have a property that's more harmoniously operated with the neighborhood and its kind of its makeup and its character. I think that part of it, to the extent we will stipulate that we hear that. And we understand that, and it's in our intent, or excuse me, I should say, Grace Investments intent to be able to operate the property in a consistent manner as such.
Hey, if we could go back to Jude's presentation, there is a slide that did resonate with me in terms of the language regarding when there is a new property owner, that becomes an important rationale. There it is. A change in ownership is a circumstance in which staff recommends to BOZA to grant the waiver. Okay.
I just will clarify something on that.
Yeah.
There's no standards
Okay.
in Metro Code, and this is a Metro Code provision, not a Land Development Code provision. The reason why we decided when we created this to send it to BOZA is because this board is the most familiar public board on the matter of short-term rentals. But we didn't add any standards. But when it was discussed, because at one point there was a discussion about whether this should be absolute, like you violate, you sit it out for 12 months. I think some council members started to feel, well, there's circumstances, and the only circumstance that was discussed why they were debating this or considering this policy was what if a change of ownership and they had nothing to do with it.
Mm-hmm.
So the net effect of granting this is a 6-month ban, because we're already 6 months down the road, and they're going to be able to get a registration. I didn't read the public comments, but I imagine their concerns are about short-term rentals and following the rules. And, that's worth consideration. But if you are to deny this request, I believe in October this year, they're going to be able to get their 2 registrations, because in this unique case, unlike the other ones you've heard, I think in all the other ones you heard were post 2019 conditional use permits, which all also carried a provision that you had to keep an active registration. So if you didn't provide relief, they were heading towards another situation where they were going to lose their conditional use permit. That will not happen in this case.
Okay.
So just trying to give some light. I know you would like some standards to consider, but you just kind of have to hear the case. Just with the change of ownership, that was just something that I can attest was discussed when we thought of what would a scenario be. I'm sure there's other scenarios, but we weren't discussing them when we crafted this.
Okay. I appreciate that background. Thank you. If there's any other discussion? All right. Does your client wish to speak, Mr. Tandy?
Did you want to say? Did you have anything else to add?
Pretty much.
Well, wait a minute. Wait.
I can add some little bit.
Okay.
All right. Name and address, please.
Yeah, Dipendra Tiwari, 1007 Woodland Ridge Court, Louisville, Kentucky, 40245.
Mr. Tiwari, do you swear that the testimony you're about to give today is the truth?
Yes, I do.
Please proceed.
Yeah, just wanted to add everything is covered. I see that it's just a 6-month, and I see the property what I bought, that was like one of the best selling property for Airbnb in Louisville. It's one of the 5th, I think this is a 3rd ranked property sell in that. And then now I see this Derby and all that going on, and a lot of property shortage there for the rental. Hotel is all booked. You already know the city, what's the, the hotel thing are going on now due to the Derby. So I can best utilize this 6-month so that city can also make money out of transient tax. That's what I thought, and I hired him to, maybe you best explain about it, and we can go for it. It's just a 6-month, and it's the best time too. It's generally, I see that looking at all the history, I see November and December, January, it's a not good month, but these are the very good months for short-term rental. And I thought maybe we could make some money and city could make some money and people get a, facility they can leave they have been living, using that property for. So that's what I wanted to add. It would be great if you guys can consider it. Thank you so much. Yeah.
Okay, members, any questions for Mr. Tawari? Thank you, sir.
And other than that, I'm a professional, I'm a CPA, so I would abide by and compliance, whatever it is needed for the city, I'll go by that. And it's not a problem for us. It's whatever they made a mistake, that was, I don't know how they just overlooked it, but we'll try to comply with all the, rules and regulation here. Thank you.
They appreciate it. Thank you, sir. Do we have anyone, because that's the only speaker card I have. I don't have any for anyone in opposition. I mean, we do have the email messages.
Nobody's indicated they want to speak on it.
Okay, all right. So at this point, I'm closing the public hearing. We are in deliberations, excuse me, on 17 CUP 1062. So members, we've had an opportunity to listen to the staff presentation, as well as Mr. Tandy and Mr. Tawari's presentations. So is there any discussion on what you've heard today? And I do understand from Mr. Tawari that you are familiar with the requirements for registration. Okay, and understand those and can meet those requirements in the future going forward. Okay, all right. Any further discussion from the board?
We have a question, please.
Yes.
Council. If the permit follows the property, aren't the conditions under the permit and so forth automatically follow?
So if I'm hearing your question, all conditions that were put into place at the time of approval of the conditional use permit, they do go with the property, and the new property owner has to follow all those conditions. But also with that, which I tried to describe, but it's a little bit tricky to describe, is also the standards in place at the time of their approval, or the standards that they have to meet. If you change the rules of the game, which we did twice since they got their approval, they still have to meet the standards that were in place when they got their approval. That's what makes this a little bit tricky, but I don't know what conditions of approval they had, if any, but they have to meet those. But the standards that are in place now that are on the conditional uses we granted today are different than what were in place when they were approved. And they have to meet the standards that were in place when they were approved, which basically are less restrictive.
There's a feeling in there for me that it's almost like the board would be an advocate in favor of the new property owner, like in making a decision that would benefit and be in favor of the property owner simply by approving this.
I mean, it really,
The board would be correcting something that, I'm not sure how to say that, the board would be correcting something in favor of the new purchaser, who should have found that out for themselves, like a bank loan. And, suppose there's a loan on the property that they missed. And it comes time, he said, there's a loan here. There's nobody that says, well, let's forget about the loan.
So there's a point that they should have been aware that there was an issue that would have prevented them from registering immediately after they bought the property. And I presume they were aware of that when they purchased the property. But I will note just one final thing, because I worked on this provision, so I know some of the intent behind it is council were concerned about people not registering and keeping up with their registrations, because that has been a problem. People always would come in and never come back. So they wanted more provisions to to relate the bad actors as they described it at the time. So people that didn't keep their paperwork in order, and they wanted some punishments, not just that you got your hand slapped for not reapplying. So this provision was put into place to be punitive to people that didn't keep up with their applications and paying their application fees. That was the intent behind it. So the reason why we brought up the example of a property owner change, they didn't have anything to do with the violation, so it's not necessarily a penalty that should apply to them. But you don't have to grant it. I mean, this is completely up to you. There's no standards to grant it. There's no standards to deny it. I mean, it's just how you feel based on the story. I'm just only bringing up the property owner change because that was discussed as an example where maybe the board could, grant relief. And then it was meant to be punitive towards the person that didn't file the adequate paperwork and the appropriate application fees. That's a big part of it. And they just continued to operate without paying the fees, which then are intended to provide the support for short-term rentals. So if that helps you a little bit, but again, at the end of the day, there's no standards in here, and it's up to the board just to decide based on your feelings on the case and whether or not you feel relief is appropriate.
Yeah, and I understand there's no standards. We've got a case here where we have a new applicant. The slate can be wiped clean because we do not a new applicant, a new owner of the property, in guess in my opinion, considering what I've heard today, is that would be a compelling reason for me to say or to address any concerns that I had related to this. And at this point, I don't have any concerns.
That makes sense to me. But would it continue? Would they still be held to the original rules that were in place when the original
Correct. And
certificate was?
if they don't comply with those rules, you could end up in a situation where they're in timeout too.
Right.
Just like the original owner was.
And
Yeah.
But they'd have
But they
would have a
be
fair-
based on their own activities.
right. So it would be like.
And if they're a good actor, they'll just cook right
Stay
along
right on.
under
Yeah.
the rules that were approved back then.
And I could pull them up, but I believe that might get to the concern of the neighbors is I believe when they were approved, the 2-strike rule was still in effect. And that was the rule that was intended that if you were a bad operator and creating nuisance issues, you were getting noise complaints, having parties, doing all these things that were, affecting the quality of life of the neighbors, that we could take it away. So I believe they are subject to that requirement.
Mhm.
And so if they get relief today or wait until October, if they don't get relief today and start operating, the conditional use can still be revoked. It just can't be revoked over failure to file paperwork like a current. That was something we added. And if you were approved before 2019, you just don't have to meet that, or at least before the point in 2019 where we passed that rule.
Yeah, and we've heard from Mr. Tawari in sworn testimony that he understands the registration requirements and will comply with those requirements. All right, anything else from the board? Anyone ready to make a motion?
Yes, Madam Chair, I'm ready to make a motion even though I don't have the.
I think.
Make a motion to approve the waiver of Louisville Metro Code of Ordinance LMCO Section 115.516D1 to allow property owner to register 2 short-term rental units approved via 17 CUP 1062 within 12 months of being issued a citation. Based on the testimony we've heard today and the discussion that we've had as a board.
Is there a second?
Second, forward.
Thank you. It's been properly moved and seconded to approve 17 CUP 1062. As discussed, a waiver of Louisville Metro Code of Ordinances to allow the registration of 2 short-term rentals within 12 months of a citation. We're ready to vote.
Jan Horton,
No.
Vita,
Yes.
Ford,
Yes.
Rodriguez,
Abstain.
Bond.
Yes, the waiver has been approved. Thank you.